All right, we're back on the record on Mr. Schmidt's case. Let the record reflect that all the parties that were announced earlier are present, as well as Chief Wheeler of Court Services. Any announcements at this time?
Judge, I will make the following announcement, and it's not the typical announcement, so I'm going to make it and see if the court will accept it. Judge, I have reviewed the warrant to show cause with Mr. Schmidt. I can tell the court that I have went through that with him, as well as the additional facts contained within the request for revocation, as well as additional facts I've learned from Ms. Wheeler in a breakout room concerning this case. That when it comes to the allegations contained within the warrant to show cause, Mr. Schmidt wants to waive hearing. I would tell a court that's where it gets tricky after that. He tells me that he has certain memory issues because of medical problems.
Thank you.
So that his ability to stipulate is somewhat hindered, but he would waive hearing and enter somewhat like a no contest to these.
You don't want to hinder his trial experience.
Based upon what we believe the evidence will be if it goes to hearing. He's not going to ask for a hearing and would not contest the allegations. Further, Judge, if the court will accept the waiver and accept his no contest or stipulation to the warrant itself, the affidavit, that he would ask the court to consider setting the case over for disposition so that he can get letters from his physicians that would tell the court his serious medical conditions, the issues on his health that he deals with, and how that
too bad I don't have it handy.
And then we'd argue to the court how that should affect the disposition the court might hand down. So again, we're asking the court to accept the waiver and find violation, but we'd also ask the court to continue disposition so he can provide evidence of or provide certain evidence for disposition. Judge, we were previously here on November 1, and during that time till now, he and I were not able to get enough time to discuss it, to get that in advance. So we don't have that right now, and that's why we're asking for the disposition to be continued. Thank you.
Mr. Regier?
Your Honor, notwithstanding the allegations made by counsel, insofar as setting this matter over for disposition is concerned, I have no knowledge as to any of the alleged apparent medical matters referred to by counsel on the record. Officer Wheeler, Chief Court Services Officer Wheeler does appear today. At this juncture, the state is prepared to proceed to final disposition.
Well, this has been continued at the defense's request to today's date. The affidavit that they indicate they'd be stipulating to indicated on October 1st that he was indicating he wanted to go back to court. I'm not sure why he thought that he had mitigating things to obtain, that why those haven't been obtained before now. So I'm not inclined to continue this any further.
And just one last argument, if I may, Judge.
You may.
I'm looking at the warrant to show cause. He was not presented with this warrant to show cause until he was arrested. He was arrested October 28th. That is 15, 16, 17, 18 days ago, which to then have an appearance and get a court-appointed attorney and try and get ready for a hearing, that's a pretty tight schedule, is all my argument would be, Judge.
Okay, counsel, what I was looking at was
which is number one,
affidavit prepared by Ms. Wheeler that indicated that it was October 1st that he refused the dip and wished to go back to court. So I am no doubt on the other dates that you're talking about, but what do you anticipate this new evidence would be in regards to mitigation?
My client is informing me that he has medical issues that has sent him to the hospital. It sounds like 2 or 3 times since being on probation, that that affects his memory to a large extent. That does affect his ability to do probation, but not of his fault. And further, he informs me that he believes that the doctor would have statements in there concerning the medical condition and the harm that could be caused by going into the jail. So I'm just passing on.
Anxiety leads to constipation.
So I don't know if that's a fact. Doctor will do that. I just ask time to obtain it.
What's the medical condition that he's claiming?
It's acute heart failure and COPD.
And TMJ and IBS.
Who's your physician?
Dr. Farhood.
Dr. Feelgood.
You know, I just worry. I pass out a lot when I'm walking. You know, and I just.
Especially when I've been drinking.
Counsel, I'm inclined to go ahead and proceed today in the event that counsel receives information in the event that the defendant is revoked. If he is incarcerated, I would give an additional date in regards to for reconsideration once that information is received.
Yes, Judge.
So with that in mind, is the defendant still wishing to stipulate, or does he wish to have the evidence presented?
Judge, I think that would still be the same announcement, except that for purposes of disposition today, he is going to want to testify, and I'd be calling him to testify for disposition purposes.
All right. All right. Mr. Schmidt, what I'm being told is that you're not challenging, while you may not remember some of the details, you're not challenging the violations that was alleged in the affidavit by Chief Court Services Officer Wheeler. Is that correct?
Yeah.
Some of my best memories are things I don't remember.
You understand that you have a right to have the state,
as far as you know,
present evidence. That's typically done by the testimony of the probation officer. The state would have a burden of proof of showing by a preponderance of the evidence. That means more likely than not. If they meet that burden, then the court could find that you violated your probation. If they don't meet that burden, then I would not find that you violated your probation, and this motion would be discharged. You understand all that?
Not really, but
What do you have a question about?
well, you know, I dig it. I got questions about the whole thing. I'm just I don't know really what's going on. I only talked to my lawyer for like 5 minutes.
All right. This has been continued before, and I'm getting the impression you're just trying to stretch this out.
No, sir.
Jail.
No, sir, I am not. I am not. I have not.
Stop.
All right.
Mr. I'm going to go ahead. The defendant is based upon his claims. I'm going to proceed and ask the state to present their evidence.
Very good, Your Honor. If I may have 30 seconds of the court's time to get briefly
going.
organized.
Very well.
Thank you, Your Honor.
do this today, Your Honor. My health is in jeopardy right now.
What's up?
I have IBS, irritable bowel syndrome,
Mm-hmm.
and what's been going on,
Very stressful.
I'm bleeding inside.
Very well. Mr. Regier, your first witness.
Yes, Your Honor. The state calls Chief Court Services Officer Sarah Wheeler to the stand.
Ms. Wheeler, if you would raise your right hand, please. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. You're under oath. Counsel, you may proceed.
Thank you, Your Honor. Would you please state your name for the record?
Sarah Wheeler, Chief Court Services Officer, 13th Judicial District.
And are you employed at the 13th Judicial District?
Yes,
And is Chief Court Services Officer your professional title in that capacity?
correct.
How long have you worked as a court services officer?
20 years.
20 years? Okay. And are you familiar with Jeremy Michael Schmidt?
Yes,
How are you familiar with this particular individual?
I was assigned to his probation on March 18 of 2024.
Do you see Jeremy Michael Schmidt in this Zoom conference?
I do, in the court security 2 box with a white shirt with what looks to be blue plaid. And he's wearing glasses, looks to have a sore underneath his mouth.
Let the record reflect that the witness has identified the defendant.
Okay, that last
Thank you,
detail
Your
is TMI.
Chief Court Services Officer Wheeler, you mentioned that you were assigned to supervise the defendant on probation. Do you recall when this probation initially commenced?
March 18 of this year.
And was that following being sentenced for any crimes in the current action?
That's correct.
Okay. Do you recall what the original what crimes the defendant was originally sentenced to in this action?
Domestic battery, 1 count.
Okay. And this probationary period you had referred to, how long was this probationary period to last?
6 months.
Okay. And during this probationary period, was the defendant required to report to you by court order?
Yes,
Did at any time during the probationary period, did the defendant ever fail to report?
yes.
Do you recall on what days the defendant failed to report?
May 28, July 1st, and October 22nd.
Focusing on the July 22nd that you had indicated, if the court will respectfully take judicial notice of the journal entry of misdemeanor and conviction and sentencing from March 18th of 2024.
The court will, yes, I review the file. The court file is as it is.
Chief Court Services Officer Wheeler, it would appear that pursuant to the same journal entry, the defendant was sentenced in March and then given a 6-month court services probation. How was it that the defendant continued to report to you in October?
He did have some dates that he reported as scheduled.
Okay. Is there any reason why the defendant continued to report after the month of September of 2024?
Yes, and a journal entry of extension and modification was signed in September.
And this journal entry of modification, did it make any changes to the length of probation in the current case?
It did. It extended the reporting probation for 12 months from September 18 of this year. And it modified conditions to include a drug alcohol evaluation due to a positive urine screen for methamphetamine that was done on September 10 of 2024.
And this journal entry, to the best of your knowledge, did the defendant sign the journal entry?
He did.
Let's see, Court Services Officer Wheeler, when the defendant was originally sentenced in this case, did the court specifically order a domestic violence or batter's intervention assessment?
Yes.
And did the court set a specific time frame for that assessment to be completed?
Within 14 days with proof to me, the court services officer assigned to the case.
To the best of your knowledge, was proof ever provided to you concerning the domestic violence assessment?
To this date, I have no domestic violence offender assessment on Mr. Schmidt completed.
Okay. And if the court had ordered a 14-day deadline for this to be, for such an assessment to be scheduled, when would that 14 days have elapsed?
It would have been about the beginning of April of this year.
Okay. And jumping back to the journal entry of modification you had previously alluded to, was the requirement of the domestic violence assessment ever addressed in the journal entry of modification?
It was a continuation of a condition of probation that had not been met at the time the journal entry of modification was signed. It was mentioned in the top part of the modification, what would be kind of the second paragraph, as a reason for extending a probation because it had not yet been completed.
Okay. Your Honor, Chief Services Officer, Court Services Officer Wheeler, in your experience as a probation officer, is it often a requirement in Butler County reporting probations that the defendants are required to refrain from contact with illegal substances?
Correct. That's ordered in every case. It's a standard condition of probation.
Okay. So is it your testimony that a standard condition of probation for Butler County would be that during the probationary period, the defendant is required to refrain from all illegal substances?
That's correct.
Okay. Did the defendant ever admit to you to using an illegal substance during the reporting probationary period?
Yes, following positive urine screens, he then admitted to illegal drug use, specifically to using methamphetamine.
Do you recall on what day the defendant admitted to using methamphetamine?
The first admittance was on September 10.
And Judge, I'm going to object as to that allegation. It's already been resolved by the court through my client serving a sentence in the Butler County Jail. So that is something that's already been litigated and taken care of. So to reintroduce it here today, I believe would be objectionable.
Your Honor, the state would withdraw its inquiry concerning the September 10th, 2024 alleged methamphetamine use.
Well, the use of that, the file reflects that he agreed to and received a dip, so there was consequence for that. However, the court will consider the totality of the circumstances in regards to that opportunities he's had. But yes, he's received consequence in that regard on that. So proceed.
Thank you, Your Honor. Chief Officer Wheeler, after the journal entry of modification was filed with the court, did the defendant ever admit to subsequent use of illegal substances?
Yes,
And what was the date of this subsequent use the defendant admitted to?
on October 1, after another positive urine screen for methamphetamine, Jeremy admitted to using methamphetamine late on September 26th of 2024.
Barring any redirect, no further questions, Your Honor.
Mr. Patterson?
Thank you, Judge. Ms. Wheeler, you testified that there was a journal entry of modification that was signed or approved by Mr. Schmidt. Is that correct?
Correct.
In that journal entry of modification, you testified extended the probation until September 18, 2025. Is that correct?
Correct.
And specifically in September, at least September 17, when it's filed, it was extended for the purpose of obtaining a domestic violence offender assessment and following the recommendations. Isn't that correct?
That's correct.
And Judge Webster did approve that order for that condition to be included. Is that correct?
It was already an original condition of probation.
I'm not asking about the original, I'm asking about this modification. Did she acknowledge and approve the modification of obtaining the domestic violence offender assessment and follow recommendations?
Yes,
So, and you would acknowledge that today is November 15, 2024?
correct.
So that with the probation ending in September, then he would still have 10 months or so left to obtain or finish up the defender assessment. Wouldn't you agree?
Correct.
Or treatment. That modification also added the evaluation, which he did complete. Is that correct?
That's correct.
And it recommended outpatient treatment. Is that correct?
That's correct.
And again, because the probation is extended till September 18, 2025, he would still have plenty of time to complete that. Wouldn't you agree?
Correct.
During the meetings you had with Mr. Schmidt, was there ever discussions with him about medical conditions?
Yes.
And what medical conditions did he make you aware of?
He told me that he had heart failure.
Did he describe how any of these medical conditions made it difficult for him to remember things?
No.
Okay.
He talked about he had a lot of swelling and he was retaining water. Went to the hospital and got on some Lasix. I have a list of medications that he was provided, and he got some relief from that. But there was no mention about any kind of memory issues.
The medication list that you're talking about, is that something you generally request from probation officers just to verify what might be in their system?
Correct. And just in case there would be something that would come up on a urine screen. All of the listing of medications that he provided have something to do with like blood pressure, water pills, a nicotine patch, blood thinner, things of that nature.
Did he inform you of any time that he had to go to the hospital?
Yes.
And did you become aware of the specific dates that he might have been in the hospital?
The last date that he provided of any kind of hospitalization was August 26th, where he provided a patient discharge instructions to me.
Is that the only time he provided a discharge report from a hospital stay?
That's correct.
Did he report, though, that he had other hospital stays aside from that one?
After the October 1 date where he said he wanted to go back to court instead of doing a sanction, he's not provided me with any other documentation of any more hospitalizations. That's the only one I have.
No other questions?
Mr. Regier, any redirect?
Not at this time, Your Honor.
Very well, Ms. Wheeler, you are off the stand at this time. Mr. Regier, any additional witnesses?
No, Your Honor.
Mr. Patterson, any witnesses?
Your Honor, I would call Jeremy Schmidt.
Mr. Schmidt, if you'd raise your right hand, please.
Buckle up, people.
You swear to tell the truth, the whole truth, and nothing but the truth, so
I
help you
believe
God?
this is what got me into this
Yes,
mess.
sir.
Thank you. You're under oath. Counsel, you may proceed.
Mr. Schmidt, first of all, I want to ask you if you recall that on March 18, 2024, you were before Judge Webster and were sentenced by her.
Yes, sir.
And part of that sentencing did require that you be placed on probation. Is that correct?
Yes.
And it also required you get a batter's intervention program assessment. Is that correct?
Yes.
Now, as to the assessment, first of all, can you tell the court what issues you've had in getting that assessment completed?
Well, I called the places at Crystally or something, I think it's called. But I called there at 2, right after the court, and I couldn't get, I never did get anyone to answer the phone. And then she'd call me and I'd call her, but she'd call on odd numbers with different prefixes and stuff. And they said potential spam and whatnot on my phone. She didn't tell me what number she'd call off of. But I went over, I finally got in to see her, and I went to my appointment as I was supposed to, and she sent me away. She said that she canceled it because
Objection, Your Honor. Hearsay.
I'm going to permit it. The state of mind. You may continue your answer, sir.
okay. I was just saying she canceled my appointment because I didn't answer the phone the day before, but she never told me that she was going to call me the day before with a confirmation call.
Hold on, let me ask this. Approximately when was this that you went in for the domestic violence offender assessment?
Well, I went in, it was in June, I think, I went in there and talked to her, but she couldn't do the assessment. And then I went in there, I called her about every week. And then when I got to I think it was like in August that I finally was able to get in there to see her. But then she said she canceled my appointment. And
Where was this again that you were going for this batter's intervention program assessment?
it was called Chrisley Group.
Where did you get the name for this place in order to contact them?
So it's all Sarah's fault.
From my probation officer.
Okay. Now, as a part of your probation, well, let me ask it different. You agree that your probation was extended from 6 months to an additional 1 year?
Yes.
As a part of that extension, that you were to get a drug and alcohol evaluation and follow recommendations. Is that part of what you signed?
Yes.
And did you in fact get the drug and alcohol evaluation?
Yes.
And the written evaluation recommends outpatient treatment. Is that something that you can fulfill?
Yes,
Now, the modification was file stamped September 17, 2024. When did you get your drug and alcohol evaluation?
just shortly after, I don't remember the date to be positive. It was just like right after I got she gave me the flyer to get to call them. When I called them and made an appointment. And as I said, I was probably in September, because that's when, or October. No, I don't remember.
Okay.
But
The probation would expire September 18, 2025. The Batters Intervention Program and the drug and alcohol treatment, do you believe you can do those during that time?
yes,
Do you have certain medical conditions that slows you down on the ability to get some of these things done?
yes.
And what are your medical conditions that has an effect to slow you down on it?
Acute heart failure, and the heart's only working at 20%, and then they said that it's starting to COPD, and I can't breathe very well, and a lot of that's because I got the fluid on me a lot of times, and but my arrhythmia, the heartbeat deal, they talk about putting a pacemaker in next month.
And what are the physical conditions that you might have that makes it tough for you to remember or get things done?
There's no blood flow to my head sometimes, and I get, I don't disoriented and don't know what is going on sometimes, and I fall down or I'll be swollen, and I can't hardly move my legs, and sometimes I can't hardly move my chest because I'll be so swollen really bad. It's like an extra 2 inches up my back and stuff, and it pushes from both directions, and I can't breathe, and and my heart don't beat right. So, I got, if I was a dog, I'd shoot me. Yeah, I mean, I just,
You don't think right.
Sir, you understand that the use of illegal drugs while on probation is a clear violation of that probation?
yes,
If you are ordered to take a UA here today, do you believe that UA would be one that would pass without a violation?
think so.
Okay.
Well, I'm filled with
What are
confidence.
you asking the court to do here today?
I'd just like to get a little bit of time to get all my information gathered, because I didn't know what I was going to have, because I never got to talk to my lawyer, and I know what's happened has happened, but I don't know, I know so many people that do things that they're not supposed to, that I don't know, but I signed those papers, yes, but Sarah would probably tell you that I kept telling her that I didn't do the stuff at first, because but she said that everybody says that's not possible, but to get it in your system. But
What the hell
I
are you on about?
haven't done it, but I did do it for about 30 years. I mean, I don't know if it built up real bad or what. I don't know.
Well, let me
But-
ask that question again. I just want to make sure, are you asking the court to continue you on probation?
I don't understand what you're saying.
Do you want
Are
to go
you
to
asking
jail?
the court to continue you on probation so you can fulfill the conditions that have been ordered?
Yes, sir.
Okay, no other questions.
Mr. Regier?
Nothing further from the state, Your Honor.
No other evidence, Judge.
Mr. Schmidt, what was it that you said you've been doing for 30 years?
The drugs I'd been doing for 30 years. I stopped about a year ago.
Thank you. You are off the witness stand at this time. Mr. Patterson, any additional evidence?
No other evidence, Your Honor.
Mr. Regier, any rebuttal evidence?
Just briefly, Your Honor, if I may, recall, Chief Court Services Officer Wheeler to the stand.
Ms. Wheeler, you are still under oath, and
Oh,
you may
sweet
begin.
Jesus.
You may question, Mr. Regier.
Thank you, Your Honor. Court Services Officer Wheeler, you mentioned previously in your testimony that the defendant had discussed certain medical conditions with you.
Yes,
Did he ever provide you with any documentation concerning these alleged medical conditions?
he gave me a listing of medications and a hospital discharge instructions from August 26th of this year.
Did the defendant ever fail to report to you after that August 26th date?
He did fail to report to me on Tuesday, October 22nd at 2:30 as scheduled.
Did you ever successfully confirm illegal substance use after that latter August date?
Yes.
And what was that date?
Well, there were two positives, one that had already been addressed with the sanction. That happened after the August hospitalization. And then the most recent one on October 1, that also was post getting the discharge instructions.
Is it your testimony that the most recent confirmation of illegal substance use was after the defendant provided this documentation concerning a stay in a medical facility?
Correct.
No further questions, Your Honor.
Still using.
Mr. Patterson?
No questions, Judge.
All right.
Still
Ms.
crazy.
Wheeler, you are off the witness stand at this
After
time.
all
Any sir
these
rebuttal?
years.
No, Your Honor.
Very well. I'll hear closing arguments at this time, beginning with the state.
Your Honor, this is a case where the defendant has already received a number of measurable benefits. He was originally sentenced back in March of this year to a Class B misdemeanor with a domestic violence designation. The defendant received the benefit of a suspended jail sentence and probation. In order to, the defendant failed to successfully comply with probation as initially ordered, and so was granted the benefit of a modification. After the journal entry of modification was filed with the court, the court services officer has testified that illegal substance use following that was confirmed. For those reasons, the state does respectfully submit that this is a case ripe for revocation, and the state does move the court to proceed in that fashion.
Mr. Patterson?
Thank you, Judge. As has been stated, and of course, what's in the court file is that the probation was extended, and specifically is extended for 2 reasons. The 2 reasons Judge Webster extended it was to obtain and complete the domestic violence offender assessment. And between now and the new date in September of 2025, he has more than enough time to get that done, as well as it was specifically extended to obtain a drug and alcohol evaluation and do treatment. Again, there is substantial amount of time for him to complete that, so that those are two items that are not violations, because he still has plenty of time to do those. Of course, the court does clearly recognize the violations of use of illegal drugs, and the court will make a determination whether that's the evidence does support that. But that goes back to the reason it was modified. It was modified so that he could get to drug and alcohol, and he could get to drug and alcohol treatment. So the additional violation of use of methamphetamine is being addressed as a condition of probation that Judge Webster did order. So we would ask the court to let him use that additional time that Judge Webster did order, that he have until September. If there is a need for a sanction for the use of the last UA that he failed, we'd ask the court to order a sanction, but place him back on probation without extension, but just under the original term. Thank you.
Okay, just so I understand, your argument is that because his probation was extended, he has until that is, a minute before it's to expire to get it done?
Well, Judge, that is the time period to complete a probation, and that would be the time period that he has to complete those requirements. It doesn't, he's subject to a court order. The court order doesn't say complete that by January 1, 2025. So I think you'd have to read it as you must complete these before the end of your probation. I don't know of any other way I would read that, Judge.
All right, thank you.
Walked away, but a short time later you came back. Is that true?
Yeah, I was on my way to Planet Fitness.
Counsel, I'm looking at the documents in the case a little bit more. Please bear with me.
Very good, Your Honor.
Number one, know what I'm saying? Number one, know what I'm saying? We are the Law Talk with my crew. Number one, know what I'm saying? Number one, know what I'm saying? Number one.
Very well. I do find that the defendant has violated the terms of his probation. Specifically, he has missed appointments in reporting to his probation officer. Additionally, he has used methamphetamine during the period of time he's on probation. And he was sanctioned once for that on looks like September. September the 10th. He agreed to a voluntary dip or 24-hour period in county jail. He still had not completed the BIP assessment at that juncture. October 1st, he again tested positive for methamphetamine, admitted to use. Today, he says he hadn't used for a year, although he'd been a user over 30 years. I do find that the the nature of his probation in regards to considering sanctions. The court is considering the fact that he has had opportunities to and failed to get his BIP assessment. I don't read the orders quite the same way that counsel argues. Here he had 6 months to do these things. He didn't do them. Then he signs this agreement for an extension to give him more time, and he still hadn't done anything as far as getting. He did get an assessment, but then he didn't go into treatment. I think Mr. Schmidt understands this system very well, and I don't think he's taken this seriously and is not going to take it seriously. I revoked his probation. I'm going to order that he submit to a UA today. The court will consider if he wants to do a motion at a later date in regard to if he provides medical information, but I'm going to tell you, it's hard for me to be very sympathetic towards somebody with a medical condition when they continue to use methamphetamine. What do you think that does to your heart? What do you have nicotine patches? Well, that would tend to be, in regards to smokers to get them off of that. That can't help your COPD. I'm not asking for argument from you, Mr. Schmidt.
Yes, sir. Yes, sir. I apologize.
So he'll get credit for any time that he served on this case. But I am revoking and remanding him to the sheriff's office. If he refuses or fails to provide a sample within a reasonable period of time, then I'll take that into consideration as well if there's a motion to modify. So anything further that we need to address on this case today? The defendant is remanded to the sheriff custody at this time.
Judge, I did have one question.
Yes.
I just wanted to make sure about the mechanics of getting the UA completed. Would that be to get the UA done with court services before he's or some other method?
The wheels
Ms.
of
Wheeler, how
justice
would you
are going to
prefer
roll
that
you
be
right
done?
into the
I
Wayne
imagine
County
it can
Jail.
be,
All right, good afternoon in jail there. Your name, please.
Wesley L. Hatch.
Mr. Hatch, it's a felony file 234059FY. I'm going to read it to you.
Good afternoon. Assistant Public Defender Dario Sierra appearing on behalf of Mr. Hatch for the purpose of arraignment. We have reviewed the felony file. We'd waive reading at this time. He's asking a matter is set for probable cause and prelim. We screened for court-appointed attorney, and that has been granted.
All right. So, sir, you will have the public defender as your attorney for the remainder of this case. Your bond is set here at $1,000 cash or surety. You already have next court dates. You have a probable cause conference on November 27th. You have a preliminary hearing on December 4th. That's in courtroom A in front of Judge Stocksless. You will get copies of those dates and times. You must show.
Well, most of this is Alyssa's fault. And after I put it all together, she texts me and says, none of it's any good. So take that as you will.
For those dates and times.
Your Honor, may I respond?
Yes, you may.
In speaking with Mr. Hatch, he was unaware of this of this outstanding warrant. Additionally, he just spent the last 8 months incarcerated in Kent County with this matter not being addressed. Given the length of incarceration and the time he could have been handling this matter, we're asking the court to consider a PR bond. He does have an address which is updated and provided to the court, as well as the phone number. Given the length of incarceration,
Sir, did you tell your attorney how many felonies you're already out on bond for?
I don't bond for anything.
Okay. What happened to your meth case from June?
I ain't never had, you got the wrong guy. I ain't never had
Your
no
name
meth case.
Nathan Reese Witteveen?
No, my name is Wesley L.
Hatch.
Hatch.
I'm sorry, I'm looking at the wrong,
Scaring me.
no, Mr. Hatch, it looks like I got nothing on you, so we're gonna change that to $1,000 PR bond.
Thank you, Your Honor.
Well, that's why we check. All right, so those are your court dates. You should get handed them to you when they're releasing you from jail in a couple hours, all right?
Yes, sir. Thank you, Your Honor. Have
All right. Strike one. That didn't get worse. That got better.
a blessed day.
You too.
Thank you.
You too, my lawyer. You have a blessed day as well, young man. Man, he scared me, man.
All
Oh,
We're all set. Yeah, that other guy had like 2 pages of record and was habitual offender 4th, but that's not you, so don't worry.
no, sir. Thank you.
Also,
All right, Jasmine Hall is present on Zoom. She is numbers. Let's see.
This one just shows up. I think she's between selling burritos here. We've really dropped in the courtroom decorum department.
3 and 4 on the 9:30 a.m. calendar today, here for her jury trial confirmation today and trailing matter.
Okay, Jasmine Hall, good morning. Are you getting mail from the courts, Ms. Hall? You're muted. Ms. Hall?
Unmute. Okay. Hello, Your Honor. Yes, I'm dealing with homelessness right now. I'm in the process of finding placement. So I do not have, I'm accepting,
All
I'm getting the mail there, but they're going to start sending back the mail to the sender. So,
Jasmine, it's residentially challenged. Get with the times.
right now I really don't have a mailing address.
For right now, then, all I'm going to say is just as soon as you have a good place to have the mail sent, make sure your attorney and the court know.
Okay. I will do.
All right, Ms. Simmons?
Yeah, we're just asking for a good cause continuance. Ms. Hall and I do need to talk about prospective resolution.
Okay. Any input from the state, please?
Thank you, counsel.
Okay, where are you looking to set these?
Well, later December, please, Your Honor.
Later December. What do we have later December?
Is that something I'm gonna have to be in person to?
No, Ms. Hall, we just need to talk before court.
Okay.
That's helpful.
Okay, next court date will be the 27th of December.
Wow.
And that'll be for a trial confirmation with trial on the 10th and 11th of January,
Wow, that's crazy.
8th and 9th. And I'll fill out those orders here as quickly as I can.
Thank you, Your Honor. So does that mean I'm gonna have court on the 10th and 11th, Your Honor?
No.
And the 27th?
Trial would be the 8th and 9th, actually, of January.
Is that one in person?
Yes, so we'll need to talk about what the resolution will be. Yeah, that's the best thing to do.
Yeah, maybe some court etiquette as well.
Let's hear position 27, Jarrell Jones and Dontavius Flanagan.
I haven't seen this. I don't know what's going on.
Flanagan
Not one
and Jones,
second
raise
of
your
it.
right hands. You swear affirm to tell the truth and a penalty and perjury of the law?
Yes.
All right. So I'm going to start with Mr. Jones. Mr. Jones, do you have a lease with Mr. Flanagan?
We have a verbal agreement when he moved in on March of 2023.
Okay, so he's been there a little bit over a year.
Yes,
And was
sir.
that for any rental amount, any monetary amount?
500 for him and his son.
Was there a late fee?
No, sir, no late fee.
Yeah, I think no. Oral. When's the last time he's paid you?
He spent the amount September 23rd for 500.
September 23rd for 500.
But he didn't pay April, May, or June, but he did pay July, August, and September.
Okay. Well, on your warrant, you're not asking for any money.
Correct.
Okay.
Okay.
You're just saying he's past due, but you're not saying what he's past due. And but you're saying he's past due.
No, sir, because I was taking that to civil court along with other things.
Okay. Well, so you're saying the past due amounts you're trying to do in another matter, but you're just trying to get rid of possession. Is that what you're saying?
Yes.
Okay.
And to make sure that he never returned.
Okay. Well, let me ask you this then, Mr. Jones. Does he's still in possession of the property?
Well, only thing he have is the key, but he's in March he said he disposed the key, and he keep using me changing the front lock as I don't know whatever, but yeah.
Okay. Well, let's hear from Mr. Flanagan. Mr. Flanagan, did you have an oral lease agreement with Mr. Jones for $500 a month?
Good morning, Your Honor. And no, sir, we never made any agreement of such. He did take me in as a friend for me and my son when I was going through, just my little eviction. However, I overstayed my welcome. There was no agreement, no verbal agreement, no tenant agreement, no lease agreement with us. I did, however, give him money every month to kind of help with the bills for me and my son being there.
How much money did you give him every month?
It ranged. Sometimes I give him 200, 300, 400, 500. It ranges. He sent me a request. I usually will just pay it.
Okay. And when's the last time you paid him?
On the 23rd, sir, and it did say of September was my last time.
Okay. And did he subsequently tell you that he wanted you to pay for October?
Yes, sir, he did.
And why didn't you pay?
Because there's no agreement. I was doing that out of the kindness of my heart. There was no agreement to do anything. So with me paying or not paying, there was never an agreement. And if I didn't pay in March or April or whatever Mr. Jones is claiming, why are we in December and he's just saying something about it if he really wanted it that bad?
Well, that happens a lot. You'd be surprised, but more importantly, if he sent you a letter in October demanding payment, you've been paying him every month, and you guys have a oral agreement, and do you own the property? Or are you on the lease agreement?
No, sir. There's no lease agreement. There's also no verbal or text message agreement. Now, Mr. Jones did, however, text me to say something about in November rent will go up or so, or And he did send me a request for this month, but I was in the process of moving out, so that's why he didn't receive anything for October.
Did you do you still live there, or have you already vacated?
No, sir, I've been gone from there.
Okay. So you don't have possession at all?
No, sir.
Okay. And Mr. Jones, does any of his possessions still remain at the property to your knowledge?
Everything that was left in the room, I had cleaners come and that was disposed last week. They left on the 31st, before November 1st.
Okay. And Mr. Flanagan, you're not alleging anything is still of yours in the property that
That's
you want?
correct, sir. I have everything of mine.
Well, folks, honestly, it doesn't sound like we need anything because there's no writ that needs it. Do you need a writ, Mr. Jones?
I do.
And why do you need a writ?
Because I'm dealing with someone who's petty, who, how I want to say it, they think they can outsmart you. They're narcissists. They think they're right. So they'll do anything, try to prove it. So because this came up before.
How long,
and this,
so wait. I'm not here to try to, this ain't a TPO. You're saying he's gone. How long has he been gone?
He left on October 20th. So
He's
2 weeks. He left on
what do you
the
want?
31st of October.
All right. And you're saying you don't really need a writ because he's already gone.
I need a written because
I'm suspecting there's more to this story and I don't want to know it.
if he come back and tell these folks he stayed here and he still got dropped,
I understand. Okay. Well, then I will give in that regard, and it's not, we're still in the case. And you did mention about the key. I'll give the writ obviously for the clarification that he's not to return. There will be no money judgment, and that'll be the order of the court.
That's cool.
All right.
All right. Thank you.
You guys are free to go.
Reed Curran versus Brian R. Marks, file number 114665DS. This is the plaintiff's motion regarding custody and other matters. The parties are present.
I haven't seen this either.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the
But I hear it's
truth,
awful.
nothing but the truth, so help you God?
Thank you. The court was advised off the record just a moment ago that Ms. Curran has a multimedia drive that may have some information on it for evidence. We'll address that in a few minutes. This is a motion regarding custody, and I'll defer to Ms. Schultz, but my understanding after reading the file is that the parties, and again, we don't want to refer to the children's names, we just use initials. We have A and E. As I understand it, the court understands, the parties have joint legal custody, physical custody is with father, and as to E, the parties again have joint legal custody, but mother has physical custody. Is that your understanding?
Yes, that's right.
Okay, thank you. Ms. Hearn, why do you believe that we need to revisit custody?
Brian has kicked the kids out of his house.
He has what?
He's kicked the kids out of his house.
Okay, what do you mean by that?
So do you want me to just read what I have?
Whatever, however you wish to proceed.
So I'm here today to get full physical custody of my son and who was documented verbal and emotional abuse that has been going on for years with Brian and the past 2 years with his wife as well. Both of my children have come to me stating they are hurting from the things that are said to them and the things that go on at Brian's house. Both children have watched Brian and his wife arguing and screaming at each other and on occasion throwing things while they are arguing. As of now, both children have been kicked out of Brian's house on more than one occasion, this last time being the worst. Both children have said they don't feel safe or comfortable in Brian's house anymore. My son has expressed that in the last 2 years of living with his father, he hasn't felt taken care of. In the 2 years Brian has had our son, Brian has not once taken him to a doctor when he was sick, not once did Brian take our son to a dentist, not once did Brian take our son to the eye doctor. As you can see in the text messages provided, Brian seems to be not doing much and Jana is doing Brian's job. When my children who are teenagers don't conform to Brian and Jana's expectations or wants, my children are made to feel like they are terrible human beings. Both of my children have spent time wondering what they did that was so wrong that made them deserve to be treated the way they are treated. On September 11th, my son was caught with a vape at school, and my son received a 1-day suspension from school and had to take a vaping class for 5 weeks. From what I was told, my son was punished at Brian's house. When punishment was done, my son was allowed to do things with his friends. From my understanding, sometime between September 11th and the 1st of October, my son made Jana upset by not asking her son to go to a car show with him and his friends. He spent most of the end of September being talked about and told he was pretty much doing everything wrong. I had multiple texts from my son saying he can't handle living there anymore, listening to the fighting and arguing. At one point, our son overheard Jana telling Brian she was sick and tired of our son. On October 1st, Jana lectured our son on the way home from school, saying the school had a video of him buying the bait he was caught with on September 11th. I've contacted Brian to find out why the things that got said to our son were said. As you can see in the text messages provided, that blew up as it does every time. After Brian saying it was up to me now to take Jana's place caring for our son, I did just that. I told our son that we had to go get his things from Brian's house for school the next day. Our son told me he didn't want to go inside of his dad's house alone, so I sent his sister in with him and told them to record in case anything happens. As you can hear in the recording provided, things did happen. I have contacted the school and the school's police officer to find out about the video, and I was told there was no video. So at the end of the day, none of this needed to happen and was all a lie from Brian's wife. As of now, it has been a month and a half, and neither child has heard from their father. Both children have expressed their feelings to me. My son refusing to go back to his father's house. My daughter not sure what she has to do to have a decent relationship with her father. I just want what's best for both children to be done today. The mental, verbal, and emotional abuse has to stop somewhere. My goal is not to take Brian out of their life completely, but I feel like something needs to change.
So there's a lot to
There's a ton to this.
unwrap here in what you've stated, but you said that the children were kicked out. When were they last kicked out?
October 1st.
And what do you mean by kicked out?
That's on this, because I sent Aiden had, so Brian.
Don't use the child's name.
Our son had to go get his stuff for school the next day after Brian told me to take care of him, which is in the text messages. So I sent our son there to get his stuff. And when he went there, I sent him and his sister both in and told them to record in case anything happened because they were both scared. When they went in, my daughter asked for my son's cell phone that was taken away, and it kind of just blew up from there. All of that is on this.
Okay. So how old are the children?
Our son is 16 and our daughter is 14.
Okay. Regarding what the children have said to you, that's hearsay, and the court cannot consider that. Just putting that out there right now. What are you I mean, obviously you're requesting physical custody of your son, correct?
Correct.
You already have physical custody of your daughter.
Correct.
So what does that look like to you? What do you mean by you wanting to have physical custody? The same regarding your daughter?
I would like the same as what I have with my daughter, Your Honor.
So you would have alternate weekends so far with your son?
So
What is the parenting time schedule?
as it sits right now, we're 1 weekend on, 1 weekend off. Our children are always together on weekends, whether it's at Brian's house or my house.
Okay. Okay.
At this point, neither child wants to go back to Brian's house.
Okay, well, that, again, that's maybe what the children are saying. The
And
court
I
has to
understand.
find that out independently, but. Mr. Mark's spouse, what is the issue with Mr. Mark's spouse?
On numerous occasions, there's been things said from her. My children say they aren't true. When I ask about it, I'm told everybody's lying. I truly don't know. I do know I have on here Jana telling Aiden, telling our son that some things that I just don't feel like should have been said to him.
Okay. Anything else before I go to Mr. Mark?
I just want this to be solved and the craziness to stop.
Okay. Have you shared with Mr. Marks what's contained on that drive?
I have not. I guess he didn't know that it was, that this girl, that our child was recording. This is what is on here.
Okay. Mr. Marks, your response to all this.
Can I read off my phone? Sure, absolutely. Thank you. Aiden was suspended for vaping in the bathroom at school in September.
And again, please don't use the
Oh,
child.
sorry. He was suspended for 1 day. I found out he lied about where he found the vape from. On October 1st, his phone was taken away. He was told he could have his phone back when he apologized for lying and apologized to a stepfather for another incident we found out where he was being a bully. Instead, he asked me to go move furniture at his mother's house, but this was a lie. He went over there, according to his mother, crying because my wife called him a piece of. After multiple ambush texts from Carrie, Aiden, and Ellie telling me how awful my wife and I were, they ganged up on me often. It was admitted that my wife did not call him that, but she made him feel bad, which I called guilt. Carrie then said she couldn't stand what I was doing to the kid's mental health. She said this weekly to me, and she said she would keep him and wanted his phone. I refused to give her the phone. So she drove the kids over here and sent my daughter in, demanding it from me, while my son snuck upstairs and packed his bags without me knowing. She has been putting my daughter in the middle of this for years, letting her read our text messages, letting her enter the conversations by texting me how terrible I am and telling me how her mother's boyfriend is her real dad and sticking up for her mom. An hour later, the police officers came to my house and told me that, and he explained, and told me that he explained to her that I was allowed to take my son's phone, and he apologized and left. I was in disbelief that my kids would gang up on me and call the police with their mother over a cell phone. Moments later, I found out through text that the phone had concert tickets on it for the following night, which is why it was so important to them. Carrie had my son buy tickets to a band called Suicide Boys for her boyfriend, my daughter, and her son. I expressed to Carrie earlier that I did not approve of them going, especially after she says weekly how bad I am for their mental health. If she was so concerned about it, why send Ellie into arguing me about her brother's phone? Why take them to a band called Suicide Boys? They also missed a day for school for this. At this moment, I decided to be done talking to her because of her lies and accusations of my wife are getting ridiculous. We're receiving numerous texts from her friends telling us that she is going out asking people to dig up dirt on my wife. So I decided to be done talking to her. I told her, fine, keep him. I knew I couldn't reason with her in that moment, and I was processing the fact that they called the police on me for appropriately grounding my son from his phone. So I decided I needed to let the friend of court and my counselor, who I am also seeing to help me and my wife blend our family, direct me on what to do. The friend of court gave me the same forms Carrie turned in for today, but they sat on my table and I didn't know what to do or what to ask for. For years, Carrie has conditioned my kids to think that I'm a bad guy. Now I am afraid that I would look like I'm a bad guy for taking their mom to court, and they would hate me even more. Aiden begged me to get custody 2 years ago. And
again, please don't use the child's phone. I know you're reading.
Yeah.
Exciting and new.
Yep. A begged me to get custody 2 years ago, insisting that his poor grade, bad behavior had the cops called on him 3 times in 1 week, and a long court case was on him, was due to his anger at living at with his mother, his grandma, and his uncle. So I went to court, and Carrie fought me up until the morning of the hearing. You ordered an investigation, and on that night she told me I could just have him. I'll be honest, I was always wondering if she was trying to avoid the investigation. Aiden was being homeschooled. I had said no to this because I knew Carrie wouldn't follow through it. She did it anyways, and I found out she quit a few weeks into it, like I assumed what would happen. When I got custody of Aiden, his online school, homeschool, said they assumed that he went back to public school because he hadn't been active for 4 weeks. Aiden said he was just playing video games for those 4 months.
All right,
And with
what's
a
going
great
on here?
character, often volunteering at church and talking about dual enrollment. My wife, who is part of the Thumb Community Health Partnership, started taking Aiden and
After this alleged, is there a video of the school, of the purchase?
That's what we were told by the principal. They had him on video.
Okay, but is there a video?
I haven't seen it. That's what the principal has told us. She wasn't involved. When I told her Aiden got caught vaping, she texted me, "Oh darn." And that was it. She didn't want to involve in any punishment. She didn't want to have a conversation with him. She didn't want to co-parent at all with him. So me and my wife.
So after this alleged incident occurred at the school, you disciplined the child, correct? Okay. After you disciplined the child, how quickly was it after that the children stayed at mom's?
It was about the second week. We disciplined the child in mid-September. Then we found out he lied about where he got it from, and he lied about some other things that.
I'm just talking about the time. I don't care what happened. I just want to know, after the discipline, when was it that the children didn't see you anymore?
October 1st is when she came.
So about a little less than a month.
Yes.
Okay. And regarding dental appointments, sounds like your spouse does a lot of the schedule.
Yes.
Okay. And you have both joint legal custody of both children, correct?
Yes.
Okay. So when it comes to the dental appointments, you have to work together with Ms. Huron regarding scheduling and doing all that, correct? Okay. So, and I know you're working, but you also stated your spouse is working as well. Why didn't you set up the appointments?
She was taking her son and my son at the same day. So she was trying to knock it out at the same day.
Okay. So you could have made the call too.
She went to the dentist that her son has been going to.
Right.
So she tried to contact Carrie to make sure that was okay to go to that dentist, to find out Carrie was blocked from it. I don't want to have contact with her at all.
Well, see, there's the problem. There's the problem to begin with. You have to be able to communicate because you both have joint legal custody. And when you hand that off to your spouse, and I'm not being disrespectful here, but when you hand that off to your spouse and you have a mother, your former spouse, or your former significant other, I should say, that has joint legal custody, you understand where the rub can be?
I do understand where the rub can be.
Okay, because flip it here for a moment. Let's just say, hypothetically.
So basically the same thing she's doing with the counselor with Ellie to me.
Well, again, two wrongs don't make a right. What I'm trying to make the point here, Mr. Marks, that you can understand how that can rub someone the wrong way.
Oh, I understand that.
Because if she has a significant other and he's setting up the appointment for your child, I don't think you would probably like that either.
I would be fine with that.
You would?
Yes, because they would have went over it with me in a real world.
Who would have went over it with you?
The person that I would have had a conversation with them. She can't have conversations with us. I try to have conversations with her about doing anything, and it's just fighting. So I don't honestly think she's capable of taking care of either one of these children. And I would like to file for custody of them.
Well, that's up to you.
I don't understand what grounds she has to have full custody of them.
Well,
I mean,
first off, it appears to the court that the children were kicked out on October 1st. They've not been with you since, correct?
She will not communicate with me to get them back. So I've emailed the court on I think the first week of October, I've been in here twice trying to figure out what to do. I was trying to get advice from here, and all I get told is to file a piece of paper to what to do. So I've been in contact with a friend of the court 3 times and trying to get some advice on what to do with this.
Michelle, do you want to speak about it?
There were emails sent to to the general account, Mr. Holbrook responded to those. And the last response, there were emails beginning of October. The most recent correspondence was October 15th. Because the complaint that was received by our office did not contain specific dates as to the alleged violation, we declined to enforce it.
So what am I supposed to do? I mean, she kidnapped my son from me pretty much. I told him to get out of my house.
Did you hear what you just stated a moment ago? There weren't specific dates.
I don't know what to do with this.
Well,
Okay,
you have two options.
Specific dates.
Excuse me, you have 2 options. First option is you just heard the information provided. Sounds like you need to provide more information. Or number 2, seek counsel. And I'm not telling you what to do, but the friend of the court did receive the complaints, and if they don't have enough information, they can't act upon them. So it's incumbent upon you to address that.
Okay, I was working on getting those dates, and then I get this in the paper. I mean, I have all this stuff, but she beat me to it.
I get it, but have you seen the children at all since October?
I've not gone over there because they called the police on me because I took their phone. If I go over there and try seeing my children, you know what's going to happen. She's going to tell me to get off her property. It's going to be terrible. So I've gone to here.
So, her and police were called over a cell phone?
Yes, Your Honor. They were called over the cell phone because once he told me that I was responsible for taking care of Aiden, or our son, our son was going to Carroll School. So did I want him to have a phone? Yes. It's a phone that he's bought and paid for on his own.
So you called police because Dad took the phone?
Because the concert.
No, I didn't ask you, sir. Miss, I'm asking you. Did you call police because?
I did, because I'm here. You will hear his wife saying that if I wanted the phone, then that's what I had to do.
Oh, this is so ugly. And the kids know it, and therefore there is 0 discipline. And that's on her. He's not perfect. Don't get me wrong. But the kids know they can run to her, and she will protect them to the point of calling the police for him doing bare minimum discipline.
Do you want him to have any parenting time at all?
My son at this point would rather not. I personally.
This for a woman who claims to homeschool and then doesn't do anything for 4 months. Despicable.
Would like him to have parenting time, possibly without his wife involved, because that seems to be where the issue lies with the children, just from my understanding.
I see in the text messages, there's a comment here, call the cops on me for concert tickets. I'm done.
That was to our son, because that was a conversation between him and our son from my phone.
Andrew, we had the perfect one for you earlier.
How well is he doing in school right now?
Right now, well, when I got him, he had all C's, I believe. He is now failing, I believe, 2 classes. He's kind of a mess right now because of everything that's going on, struggling a little bit. I have spoken with him. He understands that he needs to do better than what he's doing right now.
Well, how do you, if he was
got to be kidding me
at a C level before this blow up and now is failing some of these classes, can you explain, other than him being a mess, what's going on?
I do know there are missing homework assignments.
And whose responsibility is that?
I've asked him about them, and he's told me that they.
No, I'm asking whose responsibility is that to make sure the homework is done?
Mine.
Who else?
It's my son.
Exactly.
To the extent I can.
Our son has also missed some days of school due to being sick. He had strep throat at one time and COVID at another time since I've had him.
And do you have doctor's slips?
I do.
Okay. Sir, what's your position on the court reviewing what's contained on that zip?
You go ahead and review it. Can I say something also too?
You'll have an opportunity.
Okay.
I just want to make sure that
Yeah, go right ahead.
do that. Okay, that'll be admitted as plaintiff's exhibit 1.
Is she allowed to do that? Come into my house and record me in my own private house without my knowledge?
I can't render legal advice, sir.
Okay. Well, I don't want it. I don't want to use them.
Well, I've already admitted it.
Oh, well.
I've already admitted it. So that's why I asked.
Okay.
So the court will review that. You communicate with each other by text message, correct? You have a smartphone?
Yes.
You have a smartphone? That's a yes.
Yes.
Okay, thank you. App close. Court is going to order that both parties are to communicate by app closed only. Emergencies are different. God forbid there's an emergency regarding one of your children and you have to make an emergency phone call or text. Get that, I understand that, but Ms. Schultz will provide you the information regarding that app. It's a free app. And what's nice about that app is all communication. You can put in doctor appointments in it. You can put child schedule in it. And by doing so, there is no question of the communication. And if the court needs to retrieve it, or if we need to get copies of it, it's available. We don't actively monitor it, but at least it's available for us to review. What is your position, Mr. Marks, on the friend of the court and myself interviewing the children?
It's gonna, I know how it's gonna be. I mean,
I don't know how it's going to be.
I know exactly how it's gonna be. She's brainwashing children into hating me. It shows it. It shows it in every single thing she does. They're gonna say they want to live with their mom because they don't have rules over there. As you can see, I go through their report cards and they're missing assignments. As you can see what I was doing with Hayden. I had structure with him. She destroyed everything I did in 2 years and 1 month. 1 month for that kid. And it's not the excuse of Aiden's going through things. Ellie's school is the same thing. Missing assignments. Her whole trimester 2 is 4 Fs on it.
But we're here on.
But I'm saying the grounds of his grades isn't because of what he's going through right now. It's because she doesn't parent when she's there. Because it shows, that evidence shows in Ellie's grades that it is not just what Aiden's going through.
Ms. Hearn, tell me about this concert. What's this about?
This concert was planned in months in advance. Brian told me that it was fine. I did ask him about it. He told me it was fine to go. There was a conversation about the band not being great. It's not a great band, but they've also changed their views. The band has, okay. He's taken them to concerts. I'm not sure where the issue lies with the concert.
Are we discussing the arc of the Suicide Boys currently? Are you serious?
It was something that was planned in advance, asked his permission. My son paid for it, for him and his sister and I all to go, just so that we could all be together, and they had a ride there. So our children went to the concert and went to school the next day. They did not miss a day of school.
This woman does not deserve custody. Plain and simple. She'll get it. She'll get it. But she is destroying these children.
Because of the concert.
You have a moment. I'm just reviewing this text message.
Who knows?
Ms. Hearn, with these text messages, who is blue and who is black?
So if you're, like, mine's not colored like yours are, but here I'm the top. This is my phone here, and then these would be Brian.
Okay. So
the blue would be Brian, I believe.
Okay, so in your text message back,
nailed it.
You say, so you're going around spreading rumors about Jay and telling people I called the cops on her. People aren't your friends.
That's him.
That's you. They hear the S you say and just tell us. Yup, just keep lying, loser. Why don't you get an effing life and worry about yourself? All you ever do is ruin your kids' lives. Grow up.
Because we had her friends texting my wife because she was asking her friends to dig up dirt on my wife.
Tell me how this text message helps the children.
It doesn't help the children at all.
So then why do it?
Because I didn't want her going around asking. Do you think it's right that someone goes around and asks people about, hey, can you dig up dirt on such and such wife?
But what's the priority here in this court when it comes to?
That's to be telling her that, hey, we know you're going around asking us.
You're missing my point. The priority here is the children.
Oh, I realize that.
That's what I care about. Your spouse or your significant other, I'll be honest with you, I don't care. And I mean no disrespect by that, but I'm looking at these children. So you wanted to say something, you get the final word on this. Go ahead.
In the Suicide Boys concert, they're a demonic band. They talk about suicide, killing each other. I took them to a Christian concert. That's where I go. She wanted to go to that concert because I want to look good to the kids, not to do the right things. She's more important. She's more worried about being a friend to these children and directing these children to have a good life. I'm not worried about being their friend. I'm worried about getting them. My job is to get them out into the world to make sure they're successful. She's more worried about them liking her.
Well, what the court is going to do
is a good argument.
The court will take that zip drive and review it. The court is going to schedule a meeting with the children. They will meet with the court and myself. And it only goes to one of the 12 factors the court has considered. There are 12 factors to determine regarding custody. I've not even made a finding yet whether there's probable cause or probable cause or change in circumstance. I'd like the opportunity to speak with children, review that exhibit, and one of two things will happen. Either one, after the interview and reviewing that, the court can either issue a written opinion or bring you back into the courtroom to determine where we move forward in this case. At this point, I think what we'll do is schedule a court date. Well, let me ask this way. The children get out of school what time?
3. Well,
3.
Well, our son is in care, so he's out at 3:20, and then our daughter is out at 3 in Lakers.
Do they have any holidays or anything like that where they get out a half day or anything like that? I don't want them to miss school.
Possibly around Thanksgiving time, they should.
I don't want to wait that long.
Yeah.
I'll have it arranged about Tuesday after school.
Okay.
Can you bring the children in?
I can.
Okay. Here's one word of advice. And this, and at our last time we did this, Mr. Holbrook and I had interviewed a child. And I can tell you, when I spoke and we had spoken with the child, you could tell the child was coached. We see that. And we're trained to spot that.
Guaranteed. Good.
I don't want anything said to these children regarding what you have to say or how you have to say it. You're meeting with the judge. That's it. Well, what am I supposed to tell the judge? The only thing you can tell the child is, or the children, tell the judge the truth. That's it. Well, what's the truth? The truth is the truth, period. If the children are coached, the court and Mr. Holbrook or Ms. Schultz will notice that. And that goes in our determination here, whether there's proper cause or change in circumstance as well. Right now, I'm right in the middle because we have potentially an issue of children not wanting to go to their fathers because either they don't like it, or 2, the disciplinary issue. On the flip side, potentially mom being a friend rather than a parent. And I said potentially. I don't know yet until I speak with these children. But one thing I think you need to do, both of you, is regarding the communication. I know that Mr. Marks, he said it, doesn't want to speak with you or address you regarding the children. You have to overcome that, both of you. And so when it comes to dental appointments, doctor appointments, school, Dad, you're the number one. Mom, you're the number one. And I'm not casting any aspersions upon your significant others. That's not what I'm saying. But it's easy to say, for instance, well, if her boyfriend, quote unquote, set up an appointment, it wouldn't bother me. I don't know about that, because it didn't bother me. I'm just being honest. If my spouse and I had a child that, you know, we're divorced, for instance, my hypothetical, and I find out her boyfriend is doing scheduling, I'd be a little upset about that. Just me. But I want to speak with the children Tuesday,
Yes, and then can come back on that Friday.
then we'll come back next Friday. Can you be both available next Friday?
I mean, if I get legal counsel, they come with me next Friday?
Sure. That's,
Okay.
that's up to you. But again, no
yeah, you need
coaching,
it,
no
my man.
nothing. The court will reserve decision on this. Prior orders will remain in effect. And in the meantime, I don't know, this is an old file, so I'm assuming there are no orders relative to communication. There are no orders relative to derogatory comments.
I'm not aware that those provisions are contained within the order. They generally handle parenting on their own.
That's fine. Yep, that's fine. Okay. Whenever you get help.
So the court is going to include two provisions as well. First, I mentioned APCLOS, and Ms. Schultz will give you that information. Number two, no derogatory comments about the other party or the party's family or friends. In other words, you know, dad's deadbeat, or mom is this, or your boyfriend is this, or your girlfriend is that. None of that. Next, no adult topics regarding the case. We don't need to be talking to our children about, well, I'm fighting for custody for you because dad is this, or because mom is doing that. None of that either. Let them be 16 and 14. Most importantly, though, sounds like the grades are slipping rather significantly. Both parents need to be working with the school district to take care of that.
Your Honor, my daughter is not failing any classes right now. I don't know what he's looking at.
Skyward? She doesn't even have a login for it.
I do. I actually got it all
Okay,
changed.
we don't need to argue between the two of you. I made the reference. We'll find out, but you need to be on the same page for this.
Well, from yesterday on her Skyward.
Mr. Marks, we don't need to poke the bear here.
Okay, I'm not. I'm just showing her what she should.
But that's what we'll do, meet with the children Tuesday. And I do meet with them, we meet with them one at a time. And after we're done, before we even start, I tell them, number one, anything you tell us will not be shared with either parent. You have to trust us on that. And the reason we do that is because I want the child to feel comfortable in telling us what may be going on. And number two, after the meeting is over, the child doesn't have to say a word to either of you about what was said. If they want to, that's up to them. I can't control that. But I want to make it a comfortable environment for them to speak. And yes, there are situations where it's a bad situation. There are other situations where one parent is a disciplinarian and the other parent is a trend. And we see that too. I don't know what we have here, but we're going to find out. But we need to come to consensus here because we have a 16-year-old and a 14-year-old. And I'm assuming the 16-year-old was suspended for a short time.
1 day.
That's not good. And so we want to make sure we address it appropriately. We'll see you next Friday. That'll be all. Thanks. And you have the grades and stuff?
Yeah.
That's on paper then?
I have Aiden's. I only have Ellie's on my phone.
Okay. Well,
I
you've
can
already
email those to you if you'd like, though.
Why don't you bring them with you next week?
I can do that.
And
Along with these,
any problem with the court looking at the grades that he has there?
No, as long as it's.
Then we'll take his paperwork as well.
Yeah, these are just printed off the Skyward.
That'll be
Behavior in this case is disgusting.
that to business names. The zip drive will go off the record. We'll see you next Friday.
One of those are from Decorum and the rest.
Well, that's ugly.
Step up to
That
bring in here and state your full name for the judge.
Joshua Wayne Simmons.
What was your last name, sir?
Simmons.
Simmons, thank you.
Microphone, we're still getting used to.
All right. You still live on Alpine Drive?
Correct, sir.
All right. Do you have a phone number?
I was on my way to buy a phone yesterday, but the lady at Walmart advised me to get it at 6 a.m. this morning because it's Black Friday, it'd be cheaper. So,
Okay.
Wait for the Black Friday sale.
Once you get your phone number, update the court with that phone number.
Okay.
All right. The state is alleging 2 charges against you. One of them is drug paraphernalia, possession or use. The other one is tampering with physical evidence. Both of those are felony charges that you have the right to remain silent, right to counsel, and right to trial on. I've scheduled you for a preliminary hearing on December 5th at 3:00 p.m. The preliminary hearing is to determine if there's probable cause to charge you with those crimes. If there is probable cause, your case will bind over to the Gila County Superior Court. If there's not, one or both of those charges could dismiss. If they take the case in front of a grand jury, which they may do.
Neck tats and pink hair. I have to say, I've not seen that combination.
You'll be notified by mail that you do not need to attend court on that date. But as of now, we don't know that, so you're ordered to appear. Also, if they don't file the complaint regarding that case, they have up to 7 years to do that from the date of your arrest. Your release conditions are as follows. Obey all orders of the court. Do not commit any crimes. Notify the court immediately if you have a change of address. Do not leave the state of Arizona without permission of the court. Make sure that you report the phone number to the court once you receive it. Do not possess or consume any alcohol or drugs without a valid prescription, and do not possess any firearms. Since they're felony allegations, if you're convicted, you could become a prohibited possessor. Can you abide by those release conditions?
I can, Your Honor.
And you'll appear in court unless you're otherwise notified not to?
Yes, I will.
All right, I'll release you on your own recognizance. Do you have any questions?
No, sir.
That'll be all then.
Head back.
Okay, Tiffany, I have your last name as Christensen, which
I've also not seen this. I have no idea what's going on.
is correct. Oh, can you unmute, please?
Justin gave me the option. Sorry, I didn't know who I was. Sorry.
That's okay.
It is Phelan. I've tried to correct it every time I've came in, showed my license. The last time I was at a hearing, I don't know why it never gets corrected.
Okay. I don't think that once a case is filed, they can change it, but I just wanted to make sure that we had the right person here.
Yes, yes, it is me. I.
We are here in the case of Alyssa Rodman versus Tiffany Phelan, also known as Christensen, case number 24-05908 PP. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court on Ms. Rodman's objection to the referee's recommendation subsequently adopted in the court's order, keeping this personal protective order in place until at least it expires on December the 18th of this.
I've seen enough. I think Ms. Rodman should win.
Year per its own terms. So as an initial matter, I would invite both parties to state and spell your names for the record. We can begin with petitioner Ms. Rodman.
Alisa Rodman. Did you say spell my name?
Yes, please.
Alisa, last name Rodman.
Thank you, ma'am. And Ms. Phelan.
Well, it's Tiffany Phelan, which is TIFFANYFALEN. I was married, got divorced about 5 years ago, and it was Christensen then, and that is CHRISTIANSEN.
Very good. Thank you, ma'am. And Ms. Christensen, this is your appeal, and it basically indicates that you think that there was new evidence which you did attach there that wasn't reviewed by the court previously, and that would result in the termination of the PPO. Is that correct?
Well, yeah, I guess, yeah, that's correct.
And here, let me swear you in so I can get it
Okay.
as testimony. If you would please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
Okay, go ahead.
So I'm actually, I was very confused when I got served with this PPO. At the last hearing, I didn't even know that there were two police incident reports to Kent County that she had called about. And let me back up. First of all, I don't even see this girl. This girl is the mother to my nephew. We have not had any contact other than just through like social media, Snapchat. She was just like back in May, Snapchatting me like of my nephew. Like we've had no altercations ever, Your Honor. We've never had any issues. My brother called me up on May 7th. I hadn't even spoken to him actually for a couple months, and he didn't know what was going on. He went to pick his son up or something. I'm not sure. Anyway, what initially I guess happened, and I've got all the paperwork now from my brother's court proceedings with Miss Rodman over this stuff. She basically tried to say that my brother was abusing my nephew. There was a CPS case. This is all through Muskegon County because they lived in Muskegon County when this all took place, when their son was like, when they moved here, when they lived with me, when they first moved here. They lived in Muskegon County. So this is all in Muskegon County. So this all started at the beginning of May. I went to her house, Your Honor, and I absolutely did leave a letter for her because I was concerned for her and for this child because I had heard she had got a new boyfriend. And this is where it really is frustrating to me because I am a survivor of domestic violence. I've had reconstructive surgery from the state of Michigan for the Victim Service Unit because of my abuser who has spent time in jail, who I have a PPO on, who I had to fight to get a PPO on. And I mean, I'm just lost. But anyway, I go to this woman's house, to her house, and I'm already in Grand Rapids. She lives where she lived. She's a long ways away from me. I don't have time. I run a cleaning business, my daughter and I do, and that's another reason I need this PPO off. My daughter and I run a cleaning business. I don't have time to go to her house to stalk her. I don't have any reason to do any of those things. So wherever she heard that through was wrong. In her initial thing, I did come and I left the letter, which is attached right here to the very first PPO. And if you read that letter, there is not one thing in that letter that is threatening or harmful. And when the policeman called me later on that evening, he said that, and I still didn't know about CPS or anything. I just didn't know why my brother couldn't get DA'd, and I was concerned. So I stopped there after I dropped my workers off in Grand Rapids, went a little further, stopped at her house, left her the note that I said that I stopped before work to see you and Dade. Just wanted you to know that I'm here for you if you want to talk. I love you and Dade very much. Love Tiff. And then I put, I promise I came here out of love and concern because I didn't want her thinking that I was coming there for my brother for any reason. I was concerned about my nephew, period.
And Dade is your nephew?
Yes. And Your Honor, they've been going through these court motions in Muskegon County. If you look it up or get a hold of Judge Pittman, you will see she has filed ex partes. Everything has been turned around and denied. My brother got put on a supervised visitation and I got named the supervisor, which Alyssa didn't want. So then she went a step further to try to make up these accusations, I guess, about me and get a PPO on me.
Supervisor?
No, because it's all null and void. Everything was found inaccurate. Everything got overturned. The judge put everything back to normal. They have another court hearing actually next Tuesday because now she just moved the child out of his school district. Like there's so much that you don't know what's going on because it's a whole nother county.
I want a PPO myself.
But I shouldn't have a PPO. I went to Miss Rodman's house one time and left a letter. She has another thing in there about a police report, an incident report in Kent County from a day that we were at court in Muskegon County, claiming that I followed her out of the courthouse, harassing her. Your Honor, you know there's cameras. I never once followed that girl. I never once left the same floor that she was on of the courthouse. That's a lie. And why did she wait until 7:00 p.m. at night to report it in Kent County rather than in Muskegon County? If you were threatened by me, you're at the courthouse. Why did you wait till 7 p.m. to report it at Kent County? That doesn't make much sense. Like, I have not done any of these things. I run a cleaning business. My name gets ran for background checks. like this is everything that she has put my brother, my daughter, this little boy through for the past however many months over all of her lies that keep getting found out that she is obviously just making up accusations and that are false. Like, I don't want this on my name, sir. I literally was signed up for a CPL class because that was the next step I had to take to protect myself. And then I get a letter from state of Michigan that I can't take my CPL class because I have a PPO. It's just, I'm sorry.
Yep. And you're thinking you needed to arm yourself to protect yourself from Miss Rodman?
No, sir. I have a PPO against my abuser.
Okay. A whole separate person,
right.
different matter.
So my point is though, is like, I get served this PPO and I'm thinking to myself, what did I do? I left her a letter. Like, I can't even like get my CPL now because my abuser constantly shows up. We're constantly in court over like PPO violations, and I don't know how he always gets out of it all. But anyway, I'm just
say the words that she said, or
sure. I need for you to tell me what went on.
That I'm not on that whole shit. I'm not with that whole shit.
I can't. I've literally been turned down jobs because it came back that when they did some background check or something, I don't even know.
Well,
and
the PPO is a civil case. It shouldn't certainly show on a
yeah, I don't know. I don't
criminal
know.
background check. Now, sometimes if they run what's called the Law Enforcement Information Network report in the county, at least if the PPO's filed those, the PPOs make their way into lien because then it informs law enforcement officers if they're called to a scene, if there's a protected individual involved. But again, that's a temporary thing. And boy, to use that as a basis for employment would be pretty questionable, I would say, on a legal standpoint.
And maybe it was, I don't know. These are just
it could be something else as well, I suppose.
Right. I'm not sure exactly. But no, I'm just, regardless, I've wanted the PPO off regardless because everything that she has stated in her thing, stating that I've stalked her and all this stuff. Like, I have not had any conversations or threatening words to her. Did I tell her that she was going to be watched by a private investigator from here on out? I absolutely did. I said something along the lines of my brother couldn't hire one, but I could because there's something going on. And obviously, like I said, there is, if you look at Judge Pittman's whatever, I mean, I've got everything from my brother's hearing. The last, like I said, they have another one coming up, but it was the judge. I have his orders from that judge. She had it all turned into CPS. I have the amendment from CPS letters telling them that the case was amended because they could not substantiate.
Is there meth involved here? I just don't know how someone can be this jacked up.
The stuff, like, I have everything against everything that she's tried to do in Muskegon County has been turned down, except for the PPO she went and got in Kent County against my brother and I. And she's actually the one that has domestic violence on her record, not me, not my brother.
There's a separate PPO against
my brother as well. Yes.
Okay.
We went and got them on us after I was appointed the supervisor. So then I still had to see her every other weekend with multiple times to get this child.
Yeah, it would certainly complicate things. I will note, I did look at the PPO here. She did not request, and I did not grant one that prohibits you from owning or possessing a firearm. Now, I believe the Michigan CPL statute says that anyone who is a respondent in a PPO, and this is a domestic PPO because she did live with you for a while, cannot obtain a CPL, and that's probably what's causing the blockage on your ability to get a CPL. So, all right. Well, I've heard your side of the story. Let me hear from Ms. Rodman. And if there are things you need to respond to, I'll hear from you again, then I can make my ruling. So, Ms. Rodman, if you would unmute, I'll swear you in and I'll hear what you have to say. If you'd please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
All right. Ms. Rodman, do you think I should remove the PPO at this time? Or are those allegations that are the basis of it still facts that warrant your protection?
Yes, they do warrant my protection. I just want to say, like, first off, she's saying that the only concern is just because there was court issues going on. I will say that I think the intent came from her brother, who was my abuser, being upset with me due to my son making claims that he was being abused by his father. And then a CPS investigation started. And then he didn't have access to his son. He was upset with me. And when he gets upset with me, there's times where whenever he wants a situation to be saved, or if he does some sort of like criminal, behavior towards me, he knows that I trusted Tiffany. And so that's the person he would send to kind of like mitigate the situation. That is why I feel concerned for my safety. I didn't have any idea that she would stalk my house until I found out from somebody else. She left a note on my door. I had trust issues with her already because of her helping my previous abuser get away with criminal charges against me previously. And she left a note at my door, and it doesn't just say, oh, this is out of love. It says, I promise no shady intentions. You can read the note. Like, why would somebody write like, oh, I have no shady intentions? Like,
that's not what was said at all.
Because she knows that that's what I'm going to assume. She knows that's what I'm going to assume. So read it.
Evidence, Nikki. Evidence. You're right. I promise I came out of love and concern, no other intentions. Keep up
No
with the
other
lies,
intention.
though.
That's my point. Why would you think I would
Nikki,
have?
listen,
why
I'm
would-
not here to argue with
All right,
you.
I can't have you both talking because I won't pick you both up on my recording. So I will give you a chance to respond, Ms. Phelan. I'm going to go back to you. But nonetheless, let me hear out Ms. Rodman at this time.
Right.
My point is that she was aware that I was concerned for other intentions, and that's why she felt the need to include it in the note. Okay, there was multiple witnesses at June 4th. If she wants to find the camera evidence to provide to back up herself or story that she says, then that's totally fine. I would be happy to wait for that evidence to come through and show that that she's wrong. I have multiple witnesses. I have multiple witnesses at the June 4th occurrence, and the CPS charges were substantiated. The amendment that my son's father recorded basically just means they can't press charges against him. They don't have enough evidence to press charges against him. This cannot be redetermined. I already spoke with somebody from CPS. These things do not go away.
Okay. All right. Let me hear the response.
I have more also. I'm sorry.
Oh, okay. Continue then, Ms. Rodman, since this is your opportunity.
So I'm saying that I think the intention for my concern for criminal behavior from either one of them, I'm not saying Tiffany is a vicious or vile person. I am saying that she will act on the behalf of her brother. I'm concerned because if there is any further issues regarding custody or whatever else, or any other issues between me and Anthony, I'm concerned for my safety from both of them.
In that case, as far as you're concerned, it's still ongoing. It's just in Muskegon County.
Yes.
That would be the child protective case, or what kind of cases?
The child protective case was actually in Kent County, but there is a separate CPS investigation going on in Muskegon, but that is not related to my child. That's related to my child's sister with another woman. So,
and that's also false. That has also
okay.
been
Well, I don't even
substantiated
want to
as
venture
false.
into that one now. Which one has a hearing that's upcoming, Ms. Rodman?
I have a hearing, I believe next week, just for, we're switching the schools because my son's school is kicking him out, because we're not in district anymore. And then he filed the ex parte to try to take custody from me.
Okay, so there is a custody issue that's ongoing, and it's in Muskegon.
Yes. Yes.
Okay. All right. Is that anything else I need to know?
At this time, that's all I have to say. Thank you.
All right. Go ahead, Ms. Phelan, with your response. You do remain under oath.
I am under oath, and that's what irritates me so much, because this girl is lying straight through her teeth, Your Honor. And all I'm going to ask of you is if I can give you every single paperwork that I have everything from Muskegon County. My brother had to do the ex parte because the judge told them that at the last hearing that she filed another ex parte, and he was very upset with her. Spoke to her only for 45 minutes about I can't even understand. That's why I'm asking you. Can I turn in every evidence that I have? Because she took the child out of his school after the judge told them both that they had to be. No, she didn't yet. he's got to leave his school on November 26th because she moved even further away, which is the thing. I don't see her. I've never seen her. My brother has never sent me to do anything. I have been abused by men all my life from the time I was a little girl, Your Honor. I would surely never help anybody. I would help a stranger on the street if they were with somebody that was abusing them.
Yeah,
And
I
that
don't
is
think
why
the
I'm
concern
concerned.
is the abuse. I think it's
But
more
listen,
about
I
your
want proof.
nephew
Where's
and the custody
my
case and you and your brother.
But listen, I wasn't even speaking to my brother. I haven't seen this girl. I don't do anything for my brother besides help with these kids. That is it. And what is the proof? The letter I left? The letter that was nice? And I made sure to talk to the policeman that night. I said, sir, did I do something wrong? I have not ever been back to her house since that day, except for the days that I had to go sit into the parking lot of her trailer park for the supervised visits. I've never spoken to her. I've done nothing but be nice to her. When we left court that one day, I did say, why are you doing this to these kids, Nikki? You're lying. You are lying. There
Well,
was
and
no
I mean,
threats. I didn't follow her out of the courtroom. The guy from the courtroom came out. So let's turn in all the real evidence. I would be happy. I've got everything. Everything she's telling you about CPS, there's no cases open. Her and this other baby mom got together, started these rumors, and the other baby mom has court cases too. She has tied my brother and I up all summer, and all I'm trying to do is work. And I don't know what they're trying to get these kids because they're in school now. I don't
Trailer park, shots fired.
know. That's not my concern. I didn't even want to be a supervisor. I tried to not be a supervisor. I didn't want any part of this.
In all fairness, I can't think about the merits of this at all. All I want is for this woman to shut up. The other one said her side was rational. I could deal with that fine. I had no problems listening to her. This woman, I just want her to shut up. I don't care what the ruling is. I just want her to stop.
And it's
Well, and now you're out of that role, it sounds like.
Right, but I'm out of that role, but I still have to deal with this. I just want the PPO done. I don't want to talk to her, see her. I don't want nothing to do with her. And I'm not going to have to after Tuesday next week because I already know Judge Pittman's not going to be very happy when he sees her rolling back in his courtroom again.
Well,
and if I can turn in all of this, if I can
what-
turn in all of this paperwork, you will see the timeline of events.
Well, here's the thing is, what's in front of me is PPO initially. You have been in front of, it looks like the referees twice.
I
And
have
there has
not.
been some
No, I have not.
supplemental information turned into the referees by both sides along the way. And the referees have both kept the order in place. And Judge
Sir, I have
Eckler-
not. I'm sorry. I have not been in front of a referee twice at all.
Well, the case has
And
been
I didn't
reviewed.
get. I
It
didn't
looks
get
like.
any.
How did her ex ever let this delicate flower go? Can you imagine? At some point, some poor bastard was married to her. And he came home from work to that. There was a fight about everything. I mean everything. Everything. Pass the salt. No. Yeah, I mean, nothing went down smoothly. I guarantee it.
Twice by the referee on objections.
No, this is wrong. Listen, what I'm telling you, sir, is I did. I went in front of referee Comar's, whatever. I went all the way back down to Kent County again because I hadn't heard anything and I didn't know what to do. I hadn't got my letter in the mail. Or no, I got this letter in the mail telling me that stuff had to be turned in on a Friday. I got the letter on a Monday. So I went down there and they gave me this name and number, and this lady has never even called me back.
Well,
so what I'm saying is,
yeah, there shouldn't be any contact right now, obviously.
can I
by the
ask a
terms of
question?
the-
I know.
the order.
Can I ask you a question, Your Honor? Can you tell
No,
me?
I'm in the process of ruling now, so I really am past the point for questions. But what I got in a very clear sense that there is still some bad blood here in the relationship. Now, your intention in giving her that note might have been good.
The judge kind of saves us. He's so cool through all this. He's so cool.
But her read of the note and, given the status, and the tension you're describing today, I certainly could see from her perspective how she could read that as I'm, planning something, to do with the nephew, not anything to do with her to expose her to abuse or anything else, but to kind of back up your brother in the custody dispute, which is clearly still a live issue that's ongoing here, as it always is with the custody of kids. And I just frankly think it is best for the two of you to maintain no contact with each other. So I'm going to leave that in place. Now, all that being said, I don't see any basis to renew that right now as we sit here after December 18th. If this stays quiet, it'll just expire as of its own terms by December 18th. That's frankly before I could give you a hearing on any supplemental evidence and submissions and set a hearing date and all that stuff. We'd be after December 18th, and I wouldn't be able to terminate the order before it expires anyway. So what I would prefer to do in this.
Did she just rage quit the hearing? She was running her mouth, but it was muted. Thank God.
This case is just leave this in place. It'll be in place for one more month. Yeah,
Judge,
granted, that is
Judge, we lost her. I'm not sure if she exited
signed off or not.
intentionally.
Okay. Well, I'll just put the rest of the ruling on the record. But anyway, the appeal is denied. Protective order remains in place.
Thank you.
Oh, good Lord. That's Alyssa's fault. Direct all comments for the last two hearings to Alyssa. Well, I mean, not the last two. The pink-haired guy waiting for Black Friday sale to get his phone. That's my fault. It was dumb, but it was short. I'll take responsibility for that. I will. All right. There you go. Happy Friday, everybody. As usual, behave yourselves. Get an Uber. I'm not bailing you out. I'll see y'all soon.